Thank you, everyone, for finding your way back here after lunch. So now we'll get started with the role of the rigors of causation, traceability, and attribution in establishing liability. And our moderator will be Judge Cam Barker from the U.S. District Court for the Eastern District of Texas.
Well, thank you, Angelica, and thank you to the Center for inviting me to be here and to moderate. Our topic for the next hour and change is causation, traceability, and attribution as it concerns liability. This is important not just to the parties, but as you heard in the panel before lunch, important to litigation funders. I think it was called the primary consideration. So this ties back to several of our morning panels. I'm also interested at a personal level, as I just issued a decision last week in a Ninth Circuit case where I was sitting in the Monsanto glyphosate litigation. So I'm curious if anyone will tell me I was wrong, and of course, total liberty to do that. Let me introduce our panelists. At the far end, David Bernstein is the University Professor of Law here at Scalia Law, where he's taught since, I think, 1994, 1995? So about 30 years. And he's the Executive Director of the Liberty and Law Center here. He teaches evidence and products liability, among other things. He's published numerous works on evidence and scientific inference, including being a co-author on the latest edition of Wigmore and Evidence. Next to him is Kathryn Sacco Jensen. She's a partner at Hollingsworth, LLP, where she specializes in the defense of complex mass tort and serial litigation. She's a member of the Defense Research Institute and has defended companies in many industries, including pharmaceuticals, medical devices, and manufacturing, and has written on drug and therapeutic liability. And then next to me is Corinne Snow, who is counsel at Vinson and Elkins, where she advises clients on environmental compliance and represents them before agencies and litigates regulatory cases. She previously had many senior positions at the Justice Department, including Chief of Staff at the Environmental Division, where she managed its litigation under over 150 laws. Is that right? 150 environmental laws. So with that, let me invite David to give some opening remarks.
Thank you. Thank you all for being here. So we're going to talk today a little bit about causation, and in my case, specifically about toxic tort, chemicals and so forth, and also pharmaceutical litigation. And as you're undoubtedly aware, since around the 1970s, courts have increasingly been faced with claims alleging injuries from various substances, be it pharmaceutical products like Bendectin, the subject of the Daubert case, or asbestos litigation, or various chemicals. And these cases have posed extraordinary challenges to the court system. We have scientific uncertainty, competing experts, claims for massive damages. These aren't your typical slip and fall in the supermarket cases. There's sometimes billions of dollars at stake. When dubious claims are granted, it could have a huge impact on the willingness of companies to invest in scientific and medical innovation. On the other hand, if valid claims aren't properly administered, it both leaves uncompensated victims and also discourages companies from taking the proper risk assessments. So courts took a while, until maybe the 1990s, or even a little bit beyond that, to reach something of a consensus on what sort of evidence you need for causation and what we are really looking at when we're looking at causation. Because the old-fashioned tort standards, it was a substantial factor, that sort of thing, didn't really work so well in this context. So they came up with a two-part burden that plaintiffs have to show. The first is what we call general causation, and the second is specific causation. General causation is the question of whether the substance at issue is capable of causing the type of injury alleged in humans. If it's not capable of doing it to begin with, it obviously didn't do it in this case. But even if you show that, you still have to show specific causation. Did exposure to that substance more likely than not cause this particular plaintiff, or in a class action group of plaintiffs, injury? Both of these are essential. But how do you prove specific and general causation? And for the most part, courts in these mass torts kind of context say we need epidemiology evidence, human population evidence. And courts, once they have this human population evidence, look to the concept of relative risk. Relative risk is a lot less complicated in the sense that it sounds, although obviously I'm not going to give you a course on epidemiology in 10 minutes. This is the very, very basics. Relative risk, basically, you take a control group, in this case, a group of people who weren't exposed to the relevant substance, and you take the exposed group, the people who are suing, who are in the class of people who are suing. So, for example, if you take the control group and the exposed group have exactly the same rate of, say, colon cancer, that means you have a relative risk of 1, same rate of colon cancer in the exposed group and the non-exposed group. And of course, you want the two groups to be demographically more or less the same, so you're not having confounding factors like age or smoking or whatever. Let's say, though, that there's a 50% higher risk in your study. 50% more people in the exposed group get colon cancer than in the unexposed group. 50% risk, we call that a relative risk of 1.5. Let's say twice as many people get cancer in the exposed group than in the unexposed group. That's a relative risk of 2. 3 times as many people, relative risk of 3, and so on. To give you a real-world example, epidemiology really came into its own in the 1960s with regard to smoking. The tobacco company said, well, how do you prove that it's cigarettes that cause lung cancer? After all, some people get lung cancer who never smoke. And the answer is they did human population studies, epidemiology, and they found that smokers who smoked 2 packs a day over a course of a lifetime were 8 times more likely to get lung cancer than people who didn't smoke. So it wasn't that no one got lung cancer if they didn't smoke, but 8 times more likely is a very high risk. So if you put this into causation terms, for general causation, to show that the substance is associated with the risk, you want studies showing a relative risk of greater than 1. There is some increased risk to the exposed group. For specific causation, to show that this particular individual, more likely than not, got their cancer or birth defect or whatever the case may be from exposure to the substance, you want a relative risk of greater than 2, more than a doubling of the risk. Why more than doubling? Well, if it's less than doubling, if you take any given person, if their risk is only 50% or 75% higher, they were still more likely to have gotten the disease or whatnot from the background risk, that risk that existed even in the non-exposed control group. Once it's more than 2, though, once the risk more than doubles, that translates into more probably than not that the injury was caused by the substance. And again, there are complications involved, but we're not going to get into that today. That's just the basics. So, for example, if you have 5 of 1,000 individuals in a control group who develop cancer of a particular type, let's say colon cancer again, but 7 out of 1,000 of the exposed groups do, that's a relative risk of 1.4. That's higher than 1. So it shows potentially, at least it's evidence, subject, of course, to counter evidence of general causation, but because it's below 2, it's not a doubling of the risk. It's not 11 people as opposed to 5. It cannot show specific causation. Now, that is the general consensus of how these things work in court. But courts don't always follow this. Courts are often attracted to an argument that plaintiffs make, which is, hey, wait a second. It's true we don't have epidemiological studies, but this is a relatively new substance. It's hard to do high-quality substances in large populations. What we do have are high-dose animal studies that we extrapolate to human exposure. We have some anecdotal case reports. There's someone who's perfectly healthy, and suddenly they took this drug, and then they got colon cancer. We have other chemicals that are similar to this one. And if this similar chemical we know from epidemiology, causes cancer, like colon cancer, why shouldn't this one as well? We have some preliminary studies on this drug. They don't quite rise to the level of a publishable epidemiological study, but maybe they give us some hint that there is a problem here. We have a differential etiology, sometimes called differential diagnosis. Well, we went to some experts and we said, hey, here's a 28-year-old with colon cancer. He has no family history of colon cancer. He doesn't smoke. He didn't have anything else. It must be this. And the response, of course, of defendants will be, well, none of that is reliable scientific evidence. And the plaintiffs will respond, well, it's true that this may not reach scientific standards of reliability, but in practice, we ask doctors and scientists all the time to reach conclusions based on incomplete, not completely reliable evidence, because we have real-world decisions we have to make. The whole regulatory process in the United States is based on generally our best guess as to whether a substance might be dangerous or not in the absence of any firm evidence. And so the plaintiffs will then, like I said, it's a very attractive argument to judges. Why should we be more Catholic than the Pope? If scientists and doctors in the scientific and medical profession are willing to make sort of somewhat speculative conclusions, and we rely on them in various contexts, including when you go to your doctor and ask what's wrong with me, why shouldn't the court system do the same? It's a very good question. It's a very valid question, and I think I have an answer to that, which is that the problem is that in court, we're not asking a group of nonpartisan, neutral experts, do you think, based on the spectrum of evidence we have, that there is more likely than not specific and general causation in this context? Instead, we have a lawyer who already knows what they want to find because it's what their plaintiff needs, and then they go looking for an expert who agrees. And that becomes extremely unreliable. So yes, when we go to a doctor often relies on incomplete information in making a diagnosis or even a causal analysis. But imagine, on the other hand, you went to the doctor, a bunch of doctors, knowing what you thought the conclusion was. Let's say you were just sitting at home one day on the computer, looking at the internet, you happen to be a migraine sufferer, and you read about this new surgery for migraines that helps some fraction of migraine sufferers, depending on their exact circumstances. So you decide to consult some experts. Should I get this surgery? You make a list of 10 leading neurologists near where you live, and you go to them. All 10 of them agree, this is dangerous surgery. There's a possibility you'll die, small possibility, but a possibility, but there's also significant possibility of side effects, so you only really want to do this if we're pretty sure it's going to work. So you go to the first 8 doctors. The first 8 doctors say, based on your case history and what we know about your migraine, unlikely to work, don't do it. 9th doctor says, I don't know enough about it yet. I'd have to see more results. We're kind of unsure. The science isn't settled enough. 10th doctor says, go for it. I'm 100% convinced that this will help you. Now, would you be wise to say, oh, I already know that I want this surgery, so I found a doctor who agrees with me, and therefore, even though he can't point me to any studies relieving my worries that this isn't really going to work and I'm risking these side effects, I'll do it anyway? Of course not. I mean, people do this, but we don't think people like that are using their mental faculties in the most efficient way. So this is pretty much it's not their fault how our system works, but in an adversarial system, this is how it works. We don't know whether the plaintiff's lawyer really just every expert they consulted said, yes, we think there's causation, or if it's just a question of they went around, there's always a spectrum, a bell curve of opinion, they went around and found the outliers who are willing to make a firm conclusion of causation without there being any reliable evidence. And that, in the end, is why the court system demands reliable evidence. In an adversarial process, you're not getting a random selection of leading experts. You're getting experts who the lawyer found who either already agree with the lawyer, agreed once, they saw this person published a study that said so, that was helpful, or was willing to look at it and said so, or sometimes, as we know, some experts aren't always honest or are willing to say so if they get enough money to say so. And the only way to separate the wheat from the chaff in this context is to ensure there's actually a reliable study that can be pointed to. It says, I'm not just making this up, I'm not just speculating, here's the studies I'm relying on, here's where I say so. Again, you might have a different view if you just had that random selection of experts, and that's also a reason judges don't like this when I say it, but that's also a reason potentially to appoint your own nonpartisan experts. You might then get a neutral view and get an idea of what the average expert would say, but if you're just relying on adversarial experts, you're not going to get that. You're going to get preconceived views that are always going to be consistent with the lawyer's theory of the case. So all of this was a long way of really stating a couple of simple things for my conclusion. First of all, the plaintiffs bear the burden of proving both in general and specific causation. And when it comes to both general and specific causation, we really want to make sure that the experts are presenting evidence that has some valid scientific studies, usually, at least in mass torts, valid epidemiological studies that show that doubling of the risk. Otherwise, you're really risking, if you relax the causation standards, you're really risking opening the doors to speculative claims that ultimately will turn out not to have panned out, and you wind up ruining an entire industry. Just to give you one last thing, for example, in the 1980s, Bendectin, spermicides, with a whole series of cases involving substances used by women who are either who are sexually active, trying to get pregnant, or trying not to get pregnant and got pregnant anyway. Birth defects, a lot of money in birth defects with lifelong care. For a while, no one would touch research on anything involving pregnant women for fear that they were going to be subject to liability based on speculative evidence. So it's not just, if we get it wrong, it doesn't really have any consequences, it's just a question of shifting money around. It really could have significant public health aspects and effects. Thank you.
Okay. Well, thank you, David. Kathryn, do you want to add anything to what David has said about general and specific causation, or talk about, how that relates to your practice areas?
Sure, I can definitely piggyback off of those comments. I am a defense lawyer. I practice in product liability and toxic tort litigation, so my perspective is clear. I've been doing this for over 20 years, and I tend to be a lead counsel in centralized litigations like multi-district litigations or state mass tort litigations, which present additional issues that need to be addressed in this context. And of course, today I'm speaking only on my own behalf and not on behalf of my firm or my clients specifically. But I think that this concept that David talked about both general and specific causation and also issues of proximate causation, that's a theme that runs through all of my litigations, and there's a lot we could talk about here today, and I'm happy to. There are two things that I wanted to focus on. First, I wanted to touch on, in addition to David's comments and some that came out earlier in the topic of the Rule 702 amendments, the idea of when to explore general and specific causation and how that can move the litigation forward and narrow what you're looking at. And also, I'm going to step aside from those points and get into a concept of who the defendant should be and sort of discuss how I would recommend that you consider not being swayed by the specifics of a certain case or a sympathetic plaintiff to change some underlying notions of tort law that can have much broader ramifications. So I'll get into that second. But on the general and specific causation, often in centralized litigation like MDLs, they're set up to take on what we call general discovery first or corporate discovery. And that can go on for quite some time, which really puts the full burden on the defendant and the full cost on the defendant up front in the litigation. And it really delays any option to talk about where the litigation would be headed because you're not getting into these important parts of the case like general and specific causation. So it's an asymmetric burden on the defendants. And we heard in the last discussion about how in MDLs and mass torts, it's pretty easy to bury a lot of non-meritorious or non-colorable claims behind a few bellwether claims that might come to the top and really load up an inventory with claims that wouldn't survive. So as David mentioned, to establish causation, you have to prove both that the drug or the product at issue is capable of causing the injury, and then in each case that it did cause that specific injury. And a lot of the specific causation will come down to what were the other exposures, what were the other products that the person used, or what are the other causes of that injury that are just in the background? There are a lot of diseases that have multiple causes or that are unknown. And so what I would ask to think about are these kind of early opportunities to explore issues of general causation so that you don't go years into the litigation before you provide what should be potentially an early out to that litigation if the plaintiffs just don't have the evidence that is needed, because we want to remember that the law lags science. It can't come to the forefront of science. So one example that is very popular, very in the news right now, is the acetaminophen MDL. Now, everyone's heard a lot about acetaminophen recently, but there was a really good order out of the acetaminophen MDL almost 2 years ago now, where the judge importantly bifurcated general causation from specific causation and heard the general causation motions to strike the experts early in the litigation, and for both sides. There were 5 plaintiffs' experts and 5 or 6 defense experts. And after hearing that evidence and doing the evaluation that David just talked about, the court concluded that all 5 of the plaintiffs' experts, their opinions were unreliable under Rule 702. And that resolved that MDL. Now, to be fair, it is on appeal, and there may be some recent statements that may impact that decision. But the fact that both parties didn't have to undergo discovery on all these other issues but could address general causation first that increased the efficiency of that MDL. And that was, you also want to consider that, if you don't have a product like asbestos where you're dealing with an injury like mesothelioma, but you have something that's much more speculative. You have the acetaminophen MDL involved allegations that acetaminophen caused either autism spectrum disorder or ADHD. Those 2 diseases have been studied for a long time. They've been around for a long time, and it is not generally accepted that there's a known cause of those diseases. There are a lot of discussions about what might cause those diseases. And so in that context, you want to get to general causation early, because if plaintiffs can't prove that, there's nowhere to go. If they can't meet their burden there's no point in going forward. And so I would compare that with another litigation where the parties were not able to explore those concepts early on. There's a litigation pending in the Northern District of Illinois, and it's called the In re Abbott Labs Preterm Infant Nutrition Products Liability litigation. It's often referred to as the NEC litigation because that involves premature infants who took cow's milk-based formulas and then suffered from necrotizing endocolitis. They call it NEC because no one wants to have to say that more than one time. And that was a severe gastrointestinal illness. Really sympathetic plaintiffs, and they were suing under a failure to warn for the makers of the formula that they took and under design defect and negligence theories. Now that was pending for about 3 years, and the judge there took a pretty what I'll call traditional schedule, and so they did corporate discovery, and then they did fact discovery and expert discovery, and they went up and they selected bellwether trials, and there were over 700 plaintiffs in this MDL. There was also, at the same time, state court litigation going on. And what happened is, before the first bellwether, the court, just 4 days before the trial was to start, granted summary judgment to the defendants in that case. And that one was actually based on proximate causation, because for the first bellwether trial, the experts or the treating physicians in that case said there was no other option for that baby. That was the only food available to that infant. There was no breast milk available and no other formula options. So they dismissed that on summary judgment for proximate cause warnings causation. When on the second bellwether trial that came up just a couple months later, again, right on the eve of trial, after both parties had moved to Chicago and were ready to try those cases, the judge granted summary judgment again. And this time it was on by excluding the general causation expert of the plaintiffs, the epidemiologist, because he relied solely on studies of infants that were under a certain weight and age. And this second trial involved an infant that was older and larger than the studies he relied on. And he just couldn't point to any evidence that actually applied to that situation. So as you might recall earlier, 702 requires that the experts not only have a reliable methodology, but that they apply it reliably to the facts of that case. And you can't extrapolate from a different dose or a different subject down to something else. So he had no evidence. And then again, that entire case went away, although even though it was right before trial and it was at the summary judgment stage, the plaintiffs asked to keep that case alive so they could take the time to do more research and form the opinions to keep that case alive past what was the summary judgment deadline for a bellwether trial case. And so that you can see the problems with that if the court takes them up on that offer, is that it doesn't give the defendants a way to ever get out or set parameters on what the litigation is going to be about and where there are limits. So that's just my plug for early discussion of general causation, of specific causation where you can, because doing it on the eve of trial just really increases the costs, I would say, asymmetrically to the defendant, but really on both parties. So it's better to know earlier if you're not going to be able to sustain those burdens of proof. I want to just switch gears from that to a different issue, because we are talking about sort of the initial concept of market share liability many people have heard about. And I want to talk about how sometimes trying to see when plaintiffs' lawyers come up with a very creative problem, a creative solution to a practical problem. So market share liability was created to deal with a bunch of, again, birth defect children who claimed to have been injured from something their mother took a long time ago, and they couldn't identify the exact maker of the drug to which they were exposed in utero because it was so long ago. So the concept of market share liability came up to make all the makers of those types of drugs responsible for the amount of the market that they owned. Well, that same idea was later applied in the concept for manufacturers of pharmaceutical products. You have branded manufacturers and generic manufacturers. So plaintiffs' lawyers are ever creative, and I appreciate it because it keeps my job interesting and keeps me employed, quite frankly. But they came up with the concept of innovator liability, which was plaintiffs' attempt to impose liability on brand name manufacturers for injuries alleged by the users of the generic drugs. So that really threatens the fundamental principle of tort law, which is that the manufacturer and seller of a product is liable only for the injuries to users of its product, not to users of its competitors' products, because that essentially would make the branded manufacturer an insurer of its competitors' products. But this came about because there is a regulatory scheme for generics that makes, the idea is to get generics to market as early as possible because they're cheaper and we want to make them available to people. And so that federal scheme that lets that happen allows the generic manufacturer to skip over doing clinical trials, rely on the branded manufacturer, and rely on the label that they use. So in Pleva v. Mensing, the U.S. Supreme Court ruled that the generic manufacturers could not be liable for a failure to warn because they were required to use the same label that branded manufacturers used. So they essentially preempted any state law failure to warn cases against generic manufacturers. So in a world where we have anywhere from 80 to 90% drugs that are taken by people are generic drugs, there were the potential for a lot of people who maybe wanted to sue somebody who had no one to sue because there was a protection for the generic drug manufacturers. That happens sometimes. We have protections in place for like government immunity and other people who are exempted from liability. It's a it's a legislative choice to protect certain actors. So the plaintiff's bar was clearly incentivized to find a workaround to that problem. And so what they did was go after the branded manufacturer under the idea that the label that they put in place earlier was it was foreseeable that the users of their competitor generic products would use it. Now, I know I have to stop, but I'll just say the problem with that, it didn't take off very far. There's only 2 states in the United States that have recognized that theory. But it was a creative endeavor. It took a lot of resources from defendants, and it still does, because obviously the plaintiff's bar wants everybody who has, that they can get into those 2 states, and that creates a lot of jurisdictional fraudulent joinder and other issues. And you still see that issue rear its ugly head in MDLs, where they're asking federal courts sitting in diversity to predict how states who haven't specifically addressed it at the high court and what they would do. And essentially, it can create an unlimited liability for branded pharmaceutical manufacturers.
I will turn it over to Corinne.
Corinne?
So I'm going to start by just apologizing beforehand. I'm in my first trimester of pregnancy, and while I will not be popping acetaminophen during this, I have found that Ritz crackers solve all wonkiness of my stomach that may come up. So if you see me popping those throughout, it's not because I needed a snack break. It's just because I didn't want to turn green in front of you. So my practice is a little bit different from what's been discussed so far. I deal in the environmental realm, and I mainly want to talk about climate change. And because it's after lunch and we're all a little bit tired, and that dessert was really good, and so we ate more of it than we really should have, I'm just going to go back to some basics and first principles for a moment. So courts are for cases and controversies, right? I know it may be a little bit different for some state courts, but Article 3 jurisdiction requires injury, causation, redressability. So what does that mean in sort of your traditional case? It means I kicked Kathryn, her leg is broken, she has come before you, and you can redress that by giving her monetary damages or injunctive relief and telling me to stay away from her and not do it again. Right? That is a traditional case and controversy. And of course, you have, as judges, have not only evidentiary responsibilities in terms of making sure causation meets the basic requirements to be in your court, but you also have a duty to make sure that there is even jurisdiction to begin with, right? Is there a case or controversy here? Does causation exist here? Obviously, the conversations today show you how far we've come from that basic scenario of me kicking Kathryn. And I think part of this is, as judges, right, you didn't take the giant pay cut and do all this extra work because you had this lifelong desire to find procedural ways to keep people out of your court, right? You want to help people. And when you see big problems in front of you and people offer solutions, I think it's very natural and very human to say, well, can we make this work in our framework? And I think as a result, you see some of the wonkiest decisions in environmental law, or you see, I'll say, precedent-setting decisions. If you think about some of the big standing decisions from the Supreme Court, things like Massachusetts v. EPA, Lujan, Bennett v. Speer, a lot of them are environmental law cases, right? Because these tend to be kind of unique fact patterns. And I think that there is a basic good human desire to try and find a remedy to them. But I would just encourage you all at the beginning to ask, is this really a case in controversy? Is this something that fits into the judicial paradigm? Because we know that there are problems that aren't, right? We know that there are things like the political question doctrine that suggest that there are just some problems out there that don't have a judicial remedy to them. So in the toxic tort scenario, we have moved away from me kicking Kathryn, and this time I have spilled a vat of chemicals into the water system, and she lives downstream from this, and she's got illnesses, and so do many other people that they think are associated with my chemicals. Right, and our courts have dealt with that kind of scenario for a long time, but it's already a far distance from, well, I just kicked her, and so it's obvious what caused her injury, right, for all the reasons that Professor Bernstein was saying before. And they've kind of gone into detail, and so I won't repeat all the reasons, all the sort of evidentiary thresholds you have in these sorts of situations and why that makes it complicated and just a traditional toxic tort situation. So what I want to talk about is climate change and why that presents an even bigger challenge to the judiciary. So climate change, if you just step back for a second, is really unique and different from these other substances for several reasons. One, it does not stay in a geographic area. A ton of greenhouse gases made in this room right here has the same impact on us as a ton of greenhouse gases released in China. They all globally disperse, right? So they are all fungible, they're all interchangeable. To the extent that anyone can prove that they are tied to any weather event, you cannot trace a specific ton of greenhouse gases from a specific source to that. All you can say is greenhouse gases writ large are causing this change. Second, when we think about anthropomorphic climate change, which is human-caused climate change, because there's also non-human caused, we're all causing it, right? Like, we are all literally breathing out carbon dioxide right now. We are all sitting in a room that is being cooled with lights that are turned on. I'm talking into a microphone. I'm sure most of us have smartphones. We, probably didn't walk here today. So we're all causing it. But we're also all among the injured, right? If climate change is happening and we're causing it, then it is happening to all of us as well. And we are all experiencing the results. And so think about that. Can you imagine any other scenario where literally everybody in the world could simultaneously be both a plaintiff and a defendant in the case? As could you, right? Like, I don't know if you have any recusal issues because you too are leading to the problem. So far what we've seen, because when people can't find solutions in Congress, they tend to go to the courts, right? And so there have been a lot of different formulations of climate change litigation that have come to the courts, but usually they're trying to go for really big players in this space. There was a really interesting case that I got to be involved with at DOJ where they were trying to sue the entire federal government for causing climate change. You also see some cases crop up where they're targeting major fossil fuel companies. The idea being along these sort of market share ideas, right? Well, we don't know whose particular greenhouse gas led to this event, but you're making a whole lot of them, so let's hold you liable. But if you think about it, there's no real limiting principle in that, right? Like, you could also have a scenario where I've got solar panels on top of my house and I've been walking everywhere all year and I decide to sue my neighbor because they have a Hummer and I can, see that they've got their lights on all hours of the day, and I say that they are causing climate change impacts on me, right? It is a weird scenario where we are all among the injured, we are all among the causes. So there's not a ton of these cases right now that are, but I think there's a real will to continue to bring test cases where they can and to try and get this theory to work. And so while you may never hear one of these cases, chances are, if you do, it's going to get a lot of attention. And so I think it's worth kind of thinking about at the front end about some of these issues. So there's now a body of experts who call themselves like attribution scientists who claim that they can actually pick out specific weather events that were caused by climate change, right? This hurricane would not have had this intensity but for climate change, and that they can scientifically prove that. And they're getting themselves published in reputable sources. And activists have been pretty frank about this. They're doing this in part because they need that credibility so that when they go to the courts, they can prove that their experts are true and that they can actually blame oil company X for having caused your home to flood during Hurricane Y. I work with a lot of clients where my clients are mainly engineers, and we're dealing with like very technical substance stuff that's going to be going to court. And they tend to get super excited about really esoteric arguments, and I always have to sort of break it to them that like judges are just really good lawyers, and lawyers are just people who went to law school to avoid taking any math or science. That may not be true for all of you, but I think it's true for a lot of us, right? And I think there's this real tendency then to be like I always tell, again, my clients, I'm like, we need to find a reason for them to read the statute and the comma's in the wrong place, and that's why we win, right? That's your comfort zone. But people are going to bring before you this incredibly complex climate science that is very politicized in both directions. And I would just encourage you to really take seriously both your duties to make sure that you have jurisdiction, that there is true causation there, and your duties under the federal rules of evidence, that you have met the evidentiary burden of letting some of this in. Finally, I'm going to talk about where this might be headed. So far in these cases, it's been a lot of tort-type claims, public nuisance, you owe me money because my property was hurt, I'm a municipality, and look at all this additional money I had to spend to fix things because storms were coming through, that they've been aiming at fossil fuel companies. But there is a movement that is in both academia and by some activists that is encouraging a theory that is called climate homicide. This is the idea that you can hold executives from fossil fuel companies personally, criminally liable for deaths caused by certain weather events because you can tie those events to climate change, and they are the causes of climate change. I hope that kind of shocks you and freaks you out. I hope you're asking questions of yourself about what about, the need for intent and like a really good causal chain in criminal liability. There's already been one test case brought this past May in Washington where a woman brought a wrongful death suit on behalf of her mother who died during a heat dome event against a number of oil executives. And again, there's a lot of funding and a lot of push behind trying to get more of these test cases to go forward. And I would leave you with the question of if we run these companies out of business because people don't want to be held criminally liable for things that happen to people during weather events, who are we going to hold criminally liable when there's no power at hospitals, when first responders have no vehicles to drive to get to any of us? Whose fault is that going to be? All right, because I have a little bit of extra time, and this has been a bugaboo that has been of mine, and I'm in a room full of judges and get to do this right now, I want to ask one more thing of you guys. I want to ask you to take a hard look at your own local rules and ask questions of your local bar about how those local rules are impacting them. Every lawyer I know has stories, both funny and frustrating, about getting briefs bounced on filing days for some of the most absurd reasons you can imagine. And I'm talking about repeat players. I had one case in the 8th Circuit where my friend in the AG's office and I were trying to file on the same day. I was an intervener on their behalf. We kept getting bounced obviously in Missouri, you file in the 8th Circuit frequently. We were getting conflicting advice from their clerk's office on what we needed to do. Finally, I was told that I was misfiling because I was suing the administrative or the Environmental Protection Agency, and I should be filing against the non-existent Environmental Protective Administration. So I don't think most judges know how challenging it can be to actually get before a judge in your court. I would encourage you to speak to the lawyers in your bar, because I will say that while I've dealt with this as at a big law firm with a lot of resources, I don't know what it's like for solo practitioners or people who don't have the same kind of resources as me and literally just cannot get their papers filed in front of you. Thank you.
Good. Thank you, Corinne. Well, I would like to get the panel responding to each other, and can I throw out one discussion question, which is how much of what you each have talked about would you classify as procedural in the language of court, something where it runs with the court, their rules of evidence, their jurisdictional standards, as opposed to the substantive law that has to be applied that might be shaped by a state legislature or perhaps by state courts as policymakers themselves in tort areas. But that's just one discussion point. Any other comments are welcome.
You know, I think something that brings all three of our presentations together is I think there has been a tendency in some courts, implicitly more than explicitly, to think, you know, the purpose of law is to do justice in some broad sense, which of course it is, but that means that the technical legal rules are of causation and whatnot. You know, I'm not going to worry about, let the jury decide who's right and who's wrong. It's a very tempting notion. And one reason, for example, I think on Kathryn's, from Kathryn's presentation, one reason judges are inclined not to go to causation issues immediately is because the plaintiffs want to prove all the bad acts that the defendant did. And sometimes, not always, but sometimes you have defendants who are irresponsible, negligent, even willful in how they went about their business, but just there's no evidence they actually caused the injury. And of course, a group of lay people is potentially going to be very tempted to say, you know what, whatever the judge's instructions are, and of course the judges don't even get, the jury doesn't even get the instructions until after the trial is over, which I always always point out in my class is a very odd feature of most jurisdictions in the United States. The jury doesn't actually know what they're supposed to be doing in any detail until afterwards. But anyway, you're very tempted if you're a juror to say, you know, oh, the defendant really acted badly. If they can disprove that they caused something, then we'll let it go, and judges sort of say, well, it's up to the jury to decide these things, not me. But I don't think, you know, I understand the sympathy there, but to me, trying to balance equities in some broader sense ultimately is something a legislature could do through legislation. It's a poor fit for the common law system. We have the rules of strict rules of causation, burdens of proof, and whatnot for a reason. One of the reasons is that we want to make sure if the jury is going to reach a decision, it's actually based on the evidence, because people do have their prejudices and their cognitive biases, and they're feeling like, well, whatever the law says, I think this person is right, this person is wrong. Maybe this wasn't, again, so much of a danger back in the day when the average tort case was a slip and fall, but if you're talking about cases against vaccine manufacturers or pharmaceutical companies that are researching life-saving drugs and so forth and so on, if they don't have some assurance that they're not going to be held liable in multi-billion-dollar verdicts based on actual evidence of wrongdoing, as opposed to, well, you know, we had one really irresponsible risk manager who created a lot of really bad documents that make us look bad, it's going to really inhibit innovation and make all of our lives a lot poorer. So, I think there's, again, a temptation to say, well, let's look at the case in total. Let's not just look at causation, but also look at who is in the, we have a very sympathetic plaintiff here and a very unsympathetic defendant, and that's a natural human tendency. But if we let the legal system decide cases primarily or even based on who we think is the more sympathetic character as opposed to do they actually meet the legal standards, all sorts of chaos and trouble will ensue.
I certainly agree with that. And of course, my defendants, my clients are all, have all perfect actors. They're going to be large companies. They're filled with people. You can guarantee somebody is going to have sent some silly email at some point that will be used against you. Does that mean that you should be liable for causing something like homicide of the earth? Probably not. And so again, it gets to that timing point. A lot of times in my practice, we are really spending so much upfront time on that corporate liability before, like in the pharmaceutical practice, we have the learned intermediary doctrine, which essentially it's a proximate cause issue. It's our duty, the duty of pharmaceutical manufacturers runs to the prescribing physician, not to the patient who takes the drug, because we acknowledge that patients are going to discuss the drug with their doctor, who is the learned intermediary. So that often gives pharmaceutical defendants a really good defense that, even if we had changed the warning label, that wouldn't have changed that prescriber's practice. So if you're alleging a failure to warn, did that actually proximately cause your injury? If the doctor says, hey, that was a treatment for cancer, this guy was going to die, I would have prescribed it anyway. Even if they knew it was a signature injury they didn't know about, they might have said, there was no other option for me, I was going to save that guy's life. The defendant in that case should have an opportunity to get that discovery, to get to depose those prescribing physicians before they're 4 years into the case, having all of millions of dollars spent on corporate discovery, all hundreds of people deposed from the company, to have a chance to see what's on the other side of the equation. What are the prescribing physicians saying? What is going to happen on the plaintiff's side of discovery?
I think in the climate cases, these are all procedural and threshold issues, and everything could get decided there. For those of you who haven't seen or followed the now finally over Juliana litigation out in the District of Oregon, this was fascinating. This was a group of children plaintiffs who brought suit against the entire federal government for causing climate change. And it's a great model if you want to understand how to make your Court of Appeals angry. This case got mandamused 6 separate times before it finally got dismissed. Yeah, most ever in history. But the judge clearly knew that she had jurisdictional issues, but decided we're going to have a trial just on harm here, and then we're going to have a separate trial on redressability, because it was pretty clear from the beginning that there was not going to be a way for a single district court judge to enjoin the entire federal government and force them to come up with a plan to impact the climate. But again, I think from the beginning there was this correct instinct that this really isn't something that one judge can handle, but I basically want my show trial. The judge said there, this is going to be the next Scopes monkey trial. And I think that's frankly what a lot of the activists in this space are looking for. They don't even think they're going to get a win, but that's okay. If they can nudge the law just this much, or if they can get the headlines, that's what they're trying to use your courts for.
Let me ask the panel a question. One of the 3 titles for our panel is Traceability, and we've been talking a lot about tracing alleged harm to the individual plaintiff. How, if at all, are you seeing the analysis change when the plaintiff is a public official authorized to represent the entire public, like an attorney general on behalf of a state? I have to play devil's advocate a little bit here. Are you, maybe seeking injunctive relief only? Are you seeing courts adopt a different analysis in that context?
I do think it's been really interesting to see how active the state AGs have become in the past decade. At least in my space, you can basically guarantee that both blue and red states are going to file in whatever major environmental rule you have going on, usually both sides on opposite sides. It will be really interesting to see how it plays out. And how the courts sort of receive those additional voices.
Well, another topic, maybe this to getting to the nitty-gritty a little more of Kathryn or David, issues you've studied. Can you tell us a little bit about, in this era of big data, is there any role for meta-analysis in proving liability in your view?
So meta-analysis is basically you have a bunch of studies that are inconclusive or maybe inconclusive, and you basically reanalyze the data and try to reach a conclusion based on all the data that you couldn't get from just looking at the individual studies themselves. Obviously, this involves a lot of extremely sophisticated statistical analysis, and it has to be done well, it has to be done right. The studies may have different groups of controls with different, it's very hard to combine data from different studies, but I'll just tell you a cautionary tale. In the Bendectin litigation, there were like 40 studies by the time the case got to the Supreme Court, and none of them had anything more than very slight evidence of general causation at best, but probably either completely negative or probably just statistical noise because the relative risk was so low. But someone named Dr. Shanna Swan, who was at the California Department of Epidemiology, claimed to have done a reanalysis of the data to show there was a statistically significant relative risk that could potentially prove even specific causation, but at least general causation. And the Ninth Circuit wound up dismissing the case both before and after the Supreme Court, saying first that her data was not peer-reviewed and published, or wasn't generally accepted, but afterwards that wasn't reliable. The cautionary tale is that I ran into someone. I was at a post-Darbert conference, and I met someone who was working with who was very much convinced that Bendectin would ultimately, the philosophy of science professor's graduate student, and she was very much convinced, based on what her professor had told her, that Bendectin would ultimately be shown to cause birth defects. The Supreme Court was making a big mistake, and I said, "Oh, come on. There's these 40 studies." She goes, "Oh, but what about Dr. Swan's analysis?" I said, "No one has seen it. It's, she hasn't published it. No one knows the data." And she said, "Well, I spoke to Dr. Swan last week. This is 1994, and she said that it's going to be published within the next year." It's 31 years later, still hasn't been published.
I'll second that. A meta-analysis is typically done when there is not existing epidemiological evidence to support a theory of causation. And so you want to compile a bunch of different types of cases together, randomized controlled trials with case reports or case series that all looked at different endpoints, and then you want to gather some mathematical conclusion out of that. It's rarely done well, and I think it's a very it's a telling endeavor when that has to be done. How about that?
Well, David, you mentioned publication. One thing we see often in courts on Darbert motions is the proponent of the evidence argues, in fact, the study has been published, and it was published in a peer-reviewed journal. Can you tell us, or Kathryn, any of you, can you speak to a little bit of some of the background that you may be seeing and how you might seek to add some context to that, and specifically with regard to funding, what are courts not seeing that may be going on behind the scenes?
I can give one example of that, and this is not something I'm personally involved in, but it's been publicized a lot. So in the talc litigation, which is sort of the, third, fourth, fifth iteration of asbestos litigation, you had the plaintiff's leading expert, Dr. Moline, had generated really a case series where she looked at her own patients. There was really no epidemiology about cosmetic talc causing mesothelioma. The theory is that it's contaminated with asbestos. So asbestos, maybe everyone kind of accepts the link with mesothelioma, but a product that's allegedly, in some cases, contaminated with some form of asbestos, that was a harder lift. So you had a plaintiff's expert who published in a peer-reviewed article, or peer-reviewed journal, an article looking at 33 of her patients that she had drawn from litigation. But she obviously didn't disclose to the peer-reviewed journal the details of those patients. They just saw what she had written up. So in litigation, over years, the defendants tried to get the details of those patients. Long story short, eventually came out in what she had written up was none of those 33 patients had any other exposures to asbestos. They were only exposed to talc. Well, as the discovery came out after years, after it had been published in a peer-reviewed journal, about half of those patients had filed workers' comp claims for exposure to asbestos. And that's what came out, and there was no way for the peer reviewers to know that detail or to question that detail other than to take her statement that was just not true.
And let me ask if anyone has questions after Corinne's remarks, if you can start lining up.
Yeah, I was just going to say, think about this in context of law review articles. How many of you worked on a law review in law school? Right, so you remember the process of like, we, all-knowing 2 and 3L, selected for publication like the scholarly things that other people would cite in courts because we knew so much about the law back then, right? And we all sort of still buy into this like paradigm of like, oh, well, if it's published in a law review, then like it's worth citing. But like, it's a bunch of kids without law degrees yet who are picking out the articles.
I'm reminded of a story I read recently that said people from a certain part of Italy have amazingly long lifespans, and people thought it was because of their diet. And someone came out recently and debunked it and said, oh, everyone's just committing benefits fraud. Right? Was that peer reviewed?
Yeah, they're not reporting the deaths of their grandparents. They can keep collecting their checks.
Yeah. We have a question over here.
I have a question about, you described climate homicide, being personally and criminally liable for deaths that are caused by climate change. And if you can speak to when the actus reus, the mens rea, is Mother Nature, how does that impact? And we know that Mother Nature can, regardless of the level of preparation, can always change course. And then conversely, if there is to be causation for a climate homicide, could it not be litigation resulting from those, whether it's a business or a home, you relocate your family, you close down your business with the anticipation of a storm or whatever the climate prediction is, only to find out that nothing has happened? Can you then be compensated for those preparations?
Those are fantastic questions. If it wasn't clear enough for my presentation, I think this theory is complete garbage, right, and should not be in our courts. There are, unfortunately, tragedies that happen in this world for which there is no cause that we can go into a court and get the problem fixed, right? That is just a fact of life on this planet.
You know, just to pick up on what Corinne said earlier about plaintiffs not necessarily wanting to win but just get publicity, it's something that has always bothered me as a professor and as a citizen, that we have, it's not just in that context, every once in a while you'll see a lawsuit that you just know is going to lose, and yet it's in every newspaper. McDonald's has made me fat, and now I'm going to sue McDonald's for selling Big Macs. You know that this isn't going anywhere. No one's forcing you to eat the Big Macs, and you know that they're not good for you. But it's headlines everywhere, and it's really brought by people who are activists who are trying to get publicity for the fact that they think that, you know, this food is unhealthy, we should regulate it more, we should have taxes on you know, bad foods, whatever. And I just really think that this is a improper use of our legal system. You know, in other countries they have loser pays and other ways of dealing with this. It's very hard. You know, we don't sanction people very often in this, but it's something, you know, if I was personally a judge, I would not have much patience for lawsuits that are basically PR campaigns disguised as litigation.
Thank you, Dave. Judge Alvarez?
So on the question of climate change, I remember seeing some time ago, story I think it was out of Italy, where the weather forecasters were, I don't remember if it was criminally charged or civilly charged for failing to predict some weather event that caused a lot of damages. So you talked about the climate homicide. And we've also heard that there are many times when plaintiff's bar is trying to be innovative about what they bring, and they file a lawsuit knowing it's going to be a loser, but hoping to nudge the law just a little bit. So my question is on the issue of climate change, have you seen here in the States any cases where the weather forecast, whoever has come up with that weather forecast is being called to task civilly or criminally for not properly predicting weather events?
I have not, and I hope we don't get to that place. There's a joke I've heard, what's the difference between God and a judge? God doesn't think he's a judge. But I am certainly not God. I do not know why certain terrible things happen in this world and why certain beautiful things do. But I think it is very dangerous to start holding each other criminally liable for the disasters that happen in this world.
Thank you.
I have a sort of related anecdote where something that kind of was shocking to me after I looked into it. So my wife and I just were buying an apartment. She's from Israel, and we just decided to buy an apartment in Israel, and we got a reasonably good, a better deal on it than apartments are very expensive. We probably could have afforded it, but we bought one with a form of construction that in Hebrew is called palkal, and it's 20 or so years ago, there was a wedding hall in Jerusalem that collapsed and killed like 30 or 40 people, and it was done with this form of construction. But the people who had owned the building also took out some retaining walls and did some other architectural things that really led to the collapse. So before we bought this, I looked into, is this really dangerous? So meanwhile, it turns out that since that event, not a single building, and there were thousands of them in Israel, has collapsed because of this form of construction. So so that persuaded me that the real problem was taking out the retaining walls and not that this was so inherently dangerous. The shocking part of it is that not just the owners of the wedding hall who had actually done criminally negligent things like take out retaining walls, but the person who invented the technique went to jail. They prosecuted the architect who invented this for being criminally negligent in recommending this, because a lot of people died, and it was a very horrible tragedy, and politically speaking, they wanted to find, scapegoat people. So we always want to be careful about, attributing criminal liability to someone who just happened to be in the wrong place at the wrong time, essentially.
Could I ask the panel if you have any reflections on how the issues of attribution and causation that we have talked about may intersect with one of this morning's panels on litigation finance? Specifically, I think maybe, David, you talked about the human instinct to show people their day in court. Have you seen any impact of judges coming at that differently in light of maybe litigation finance motives for being in court?
Well, because we have a contingency fee system and because we don't have fee shifting except in Alaska. I saw a case from Colorado, oddly enough. I was surprised. Maybe they've moved to that also. But anyway, there's always a weird phenomenon in the U.S. where, if you're a lawyer thinking about whether to take a case, and plaintiff's lawyers will say this isn't true, but it has to be true. If you're thinking about how to take a case, what you're looking at is the ultimate value of the case, right? And the ultimate value is, what are the chances I'm going to win versus the payout? So you'd much rather, as a plaintiff's lawyer working on contingency fee, take a case with a 10% chance of winning with a potential payout is $5 million. That case is worth $500,000 on average, right? If you have 10 times you win once, then take a 100% chance of a $100,000 case. But one of the big ways that one reason why plaintiffs lawyers say we wouldn't take those cases, we don't want to take the risk, because we're not going to take a speculative case where there's only a 10% chance of winning and have to pay all those fees. We don't have the resources to lose cases like that. Well, once you got litigation financing involved, you do, because now you have companies that are acting like surety companies, like insurance, where they just say, well, we just know that if there's only a 10% chance, if the 10% chance of winning is because we put one over on the jury or because we have a particularly lenient judge or whatever the case may be, and we can predict that will be about 10% of the cases, it is worth it to take those $5 million cases, which probably shouldn't be brought. So to me, that is a big danger of litigation financing. One thing that really inhibited lawyers from taking extremely speculative and probably bogus cases, but that with a large potential payoff if they just win once in a while, is they couldn't afford to take that risk. But now if they have big investment banks backing them or whatever, they can afford it.
And my cases that I'm talking about, it's a different type of financing, right? There's a political agenda behind it. And look, I don't mean to malign all the people who do this. I think there are plenty of true believers who really do think that climate change is the end of our whole world, and they're trying to stop it in any way they can. But it means that they're willing to roll the dice on all sorts of loser cases to try and move the case law this much, right? The 12 kids in the case I was talking about that went up on mandamus 6 times, they weren't self-funding, right? So that they could get their injunctive relief in this. Like, there was no payout for them at the end of it. So at least in the climate space, you see a lot of people doing economically irrational things because they're trying to get to a political outcome, which is, again, why I would argue this is really a political problem that needs a political solution rather than a judicial one. There's a question.
Oh, please.
Isn't that why they're doing it? Because they're unable to achieve a political resolution? Because we have a legislature that's abdicating their responsibility to do anything meaningful about climate change?
Yes, and I think that's very frustrating to people, but I don't think it's a reason to turn our courts into a legislature.
Any other questions? Well, I guess one parting question for you, Kathryn. You talked a little bit about case management. How receptive have you found courts to your suggestions of changing their standard case management techniques? And do you typically view yourself as being fairly responsive or more proactive as a litigator?
I think it's very beneficial to be proactive, and I think that, I've had several now centralized litigations where I appear before a judge who says, oh, this is my first MDL, or this is the first time I've had to deal with this, and I'm going to be looking to you for suggestions. And I guarantee that the plaintiff's lawyer on the other side of me will have a lot of suggestions, and we're probably not going to agree on how it should go. But so I try and have ideas ready from other litigations and to really explain why it is going to be beneficial for the judicial efficiency and also for both sides of how we should structure it. And it will be different in each type of litigation. There is not one magic formula, but I think that's an important thing also to understand, that just because the judge down the hall from you had a similar case and it ran a certain way, there may be reasons to deviate from that. And I think that a lot of times judges think if they put a really tight timeline on getting to trial, that will put the squeeze to get to an early resolution. And it can often have the opposite impact, because there isn't always room for the parties to reach that resolution, or there's such a negative economic impact on the defendant right up front that the defendant has already spent so much money that that's no longer the incentive to move them forward. And so I think that listening to the parties and what is going to really just be very difficult for them and what makes sense, and then coming up with a compromise and not being so rigid in the approach, because it is going to work out differently in each litigation.
Thank you. Well, I see we have 2 minutes, so let me just ask one final wrap-up question, which is, as the audience, as judges continue to address these issues, can you very briefly tell us, in your view, what are some good resources that we should be looking to? Maybe David will say his treatise here, his treatise on evidence.
Oh, yeah, we'll start with the new Wigmore expert evidence. I heard the authors are pretty sharp. There's, for scientific evidence, there's the Federal Judicial Center Manual that tries to explain some issues from DNA to epidemiology and terms that judges can understand. There are other books on scientific evidence, there are various law review articles and such on various procedural techniques to manage cases. I'm going to give a plug. I know judges don't like to do this. I'm going to give a plug that to the extent that you're able to sometimes look to nonpartisan experts at the local university or whatnot. I don't like it when judges engage in ex parte communications, which they do sometimes to get advice, but because that could cause problems. But to try to sometimes even get the parties to agree. Sometimes we have legitimate disputes and the parties don't really know what the answers are, and finding nonpartisans and there's always a question of where to get the money, but sometimes as a public service, you'll even find professors willing to help out if it's not too time-consuming and complicated. So that's something else to look to.
Thank you. Well, that concludes our panel. Let me thank our distinguished panelists for a great discussion.